to address the public as well, so that the public has an idea as to what is being done. And so that larger body of legislation called the Insurance Act carries a long title which says, "An Act to revise the law regulating the carrying on of insurance business in Barbados in order to strengthen the protection given to policyholders under the existing Act, to increase the capital and solvency requirements of insurance companies, to expand the existing regulatory framework to include the regulating of all insurance intermediaries, and to give effect to matters related thereto." The civil law tends to concern itself with the rights of those who, in contractual relationships, are vulnerable, those who tend to have less power. And it is therefore not surprising that when the purpose of the Act is stated, the first purpose of the Act speaks to strengthening the protection given to policyholders. And in the relationship between a policyholder and an insurance company, the law recognizes, and certainly the statute law recognizes, that the policyholder is the weak or vulnerable party, and the primary purpose in the legislation is to protect that weaker party in a contractual relationship. And as I said, sir, that contractual relationship is between the policyholder, the member of the public who seeks insurance, and the insurance company. So permit me to repeat, the legislation states as its primary purpose the protection of the policyholder. Now, I will say what we all know, but sometimes we have to say these things nevertheless, that insurance is really a situation in which a company more or less purchases a risk. A person who has a car, for example, well, of course, in Barbados it is compulsory. A person who has a car, he pays insurance to a company. In the event that he loses that car in an accident or by whatever means, and the risk of accident or the risk of any loss of that vehicle is called insurance. The company is insuring against the risk, and if something happens to the car, the company pays you. That's almost basic, but sometimes we need to say these very basic things, and there are people who will tell you it is the purchase of a risk, so that is almost elementary. But as I said, in the relationship, the policyholder, the consumer, if we wish, he always is at risk because he is the one that's vulnerable, he is the one that has less power in the relationship. It's really an unequal relationship. And so the law intends to give him protection in that financially unequal relationship. And so this legislation today speaks to, or this amendment today speaks to enhancing a statutory fund and to make provision for a risk-based capital and insolvency regime. The public will be told that the statutory fund relates to the duty and the obligation of an insurance company to establish a fund so that there is always a reserve of monies that is available to pay persons who have suffered a loss. They've had an accident, or they have struck someone, and they are at risk, or they're liable to pay that person damages for injury. Of course, there are other categories of insurance. There's the house insurance. As the Honourable member said, there's the life insurance policy. You die, and so that your relatives, surviving relatives, do not remain in peril, in financial peril. You have a life insurance policy and that is paid. All that is rudimentary, but it needs to be said because we need to understand what this amendment is seeking to do today. And this amendment is seeking to ensure that insurance companies retain that cash reserve in the event that they themselves find themselves in some peril and there are claims being made against them, and they put up their hands and say, look, business has been bad, we cannot pay. To prevent those circumstances, the government, by this legal regime, by this law, establishes a framework in which they must have a reserve, so that not only must they have a statutory reserve, and by that one means to say that they are required to keep an amount of funds that do not fall below the statutory or the prescribed minimum, so that there's always something there for the insured person, for the consumer, for the person who buys the insurance policy. But not only does the legislation pertain to mandating that insurance companies keep that reserve of funds, they must prove their insolvency, or rather they must prove that they're not insolvent. So the legislation seeks to prevent them from finding themselves in a state of insolvency. That's a developing area in the law of insolvency. And insolvency, let the public know, relates to an inability to pay debts. So that if an insurance company finds itself unable to pay its debts, it means that it cannot meet its contractual obligations to the consumer, to the policyholder, to the insured person. And the law aims to protect creditors. The law pertaining to insolvency. If a company runs into trouble, for example, it has several debts, the law intervenes and seeks to resolve that situation in which the insurance company then falls under management, and sometimes it is even judicial management. Sometimes the court intervenes and the court appoints a manager to manage the situation of insolvency. Insolvency being a situation in which the company cannot pay its debts. And that management involves paying off creditors. And I would go as far as to say it must ensure that policyholders who are due to be paid are paid as well. Now, a lot of people mention bankruptcy, and they want to know what is the difference between bankruptcy and insolvency. Bankruptcy is a more specific form of insolvency in which assets are distributed to creditors, and the debtor, which is the insurance company that is in problems, that company becomes discharged from its debts. But bankruptcy is more specific. In a case of insolvency, sometimes the company recovers and continues to do business. So that is a general overview. The Honourable Member for Christchurch East Central did make some comments which are beyond the technocratic, which were more political than anything else. Thus far, I've resisted the urge to comment on those, to respond to those. But if I do so, before I do so, I want to look more closely at the legislation and to make some observations that catch my eye. And I want to go to Section 22A of this legislation, which falls under Section 4 of the amendment. And it says, Section 4 of this amendment says, Section 22A of the Principal Act is deleted and the following is substituted. You will permit me to read it, sir. The old 22A Let me read it, sir. Yes. The section that is being repealed by today's legislation reads as follows. A qualifying insurance company shall comply with the requirements set out in the fourth schedule with respect to its international insurance business. Beg your pardon, sir. Yes, here's the fourth schedule. I'll read it again. A qualifying insurance company shall comply with the requirements set out in the fourth schedule with respect to its international insurance business. And the fourth schedule sets specific figures beneath which a company cannot go. Rather than describing it, I'll read what the fourth schedule says. A qualifying insurance company shall comply with the following requirements with respect to international insurance business. This is the present legislation which is being appealed today. A qualifying insurance company must maintain a solvency level, and that's operative. It must maintain a solvency level. In other words, it must maintain a financial status in which it is viable, a viable concern. And subsection 2 says, unless the supervisor otherwise determines a qualifying insurance company shall not, in respect of its general international insurance business, be regarded as maintaining a solvency level if, at any time in its first financial year, the value of its assets does not exceed the amount of its liabilities by $250,000. So that the old legislation, or rather the existing legislation, is describing solvency. And it defines solvency as that difference between asset possession and liability. And it says, it states a specific figure. The difference between assets and liabilities must not be other than $250,000. I could read the others, but I won't, just to say that in another subsection, it reads, for example, that at any time after the expiration of the first financial year, the value of its assets do not exceed its liabilities by 1/5 of the premium income for the preceding financial year, where that premium income exceeded $1.5 million, but did not exceed $10 million. So that the point being made here is that specific figures are being mentioned in the existing legislation. What the Parliament comes to do today is to remove those specific figures that define solvency. As I said, Section 22 in the existing law defines solvency and refers to specific figures. Here's what today's legislation is doing. Permit me to read, sir. The new 22A, this is the 22A that will replace the existing 22A. The existing 22A refers to specific figures which define solvency. Here's today's amendment. An insurer carrying on insurance business of insuring risks located outside of Barbados and in respect of which premiums originate outside of Barbados shall comply with all requirements determined by the Commission. Those are the operative words. Subsection 2 again, subject to subsection 3, an insurer shall maintain capital, liquidity, and assets, including the custody of assets, in accordance with the requirements determined by the Commission. 3, the Commission may direct an insurer to increase capital or provide additional liquidity, as the case may be, in any form or amount. And subsection 4 for completeness, subsections 2 and 3 shall apply to Class 1 and Class 2 insurers. I use the phrase operative, or the word operative, when I read the phrase determined by the Commission. Now, what is significant about the amendment is that it does not define it does not define solvency according to figures, according to a difference between assets and liabilities. It leaves that determination now to the Commission. I know that the financial market is dynamic, that is its nature, and when you fix figures, the Parliament always needs to come back and to amend those figures by way of increase. For example, you are aware, sir, that jurisdiction in the civil magistrates' courts used to be, for many, many years, I think it was set at $2,500. If you were suing somebody for an amount exceeding $2,500, you had to go to the High Court. And that was not a tenable situation, because one of the natural incidences of economic life is inflation. And inflation is natural. It's a natural economic phenomenon. So that the law tends to lag. And in 1970, $2,500 was a lot more money then than it would be in the year 2000. So that as time passes, the Parliament would intervene and increase that magisterial jurisdiction to $10,000. I am not sure how much it is now, but it means that a Parliament has to come back and pass law to catch up with the social and economic reality. This legislation is interesting. This legislation here does not do that increase. The legislation here says to the Commission that the Commission itself, and I take it that's the Financial Services Commission, that the Commission makes a determination as to insolvency, as the financial viability of a company. And that's why I describe the words as operative. An insurer carrying on insurance business of insuring risk located outside of Barbados and in respect of which premiums originate outside of Barbados shall comply with all requirements determined by the Commission. So no figures appear. The Commission then is fixed with a heavy responsibility. And it really is a discretion. And as you know, sir, a discretion is only well exercised where it is reasonable. But the Commission is given that discretion. And one, I suppose, there can be a defense of that, because you can say that in a dynamic market, you need a public official to exercise its discretion as to what are market values or as to what is financial viability. Whereas the previous legislation, or the existing legislation today, because it exists now, the existing legislation sets a figure as to financial viability. You are moving into a paradigm, a regime, in which the Commission is given the power to determine that, and I say this loosely, to determine what is that financial liability. It does it at subsection 2 as well. Subject to subsection 3, an insurer shall maintain capital, liquidity, and assets, including the custody of assets, in accordance with the requirements determined by the Commission. Again, Your Honor, a very, very heavy responsibility on the Commission. I may go as far as to say that that is a responsibility which is handed to the Commission in this legislation, and supposing the Commission errs, as all humans do, supposing that Commission errs as to what is financial liability, because remember, Your Honor, that we are dealing here, as the legislation says, an insurer carrying on insurance business of insuring risk located outside of Barbados, and in respect of which the premiums originate outside of Barbados, shall comply with the requirements determined by the Commission. One may say that it is not going to be easy. It is not going to be easy to trace necessarily the assets and liabilities of a company in that situation. And one wonders if the legislation should not be a little stricter in relation to the monitoring of an insurance company as to its financial viability. It mandates as well, I read it again, subsection 2, that an insurer shall maintain capital, liquidity, and assets, including the custody of assets, in accordance with the requirements determined by the Commission. Again, I repeat, heavy responsibility placed on the Commission. How does the Commission, I suppose it can, but how does the Commission manage to monitor or trace the activities and the viability of these companies? That's a question that I ask, and I think it is a reasonable question to ask. Section 25, the same thing happens. Section 25 of the legislation, which is to be amended by this Parliament today, I believe. And the amending section here is section 5. Permit me to read it, sir. Under the rubric, establishment and maintenance of statutory funds. And this one is as important. This deals with the maintenance of statutory funds. In other words, the government always wants to be sure that an insurance company can meet its responsibility in the event of loss to the consumer, to the insured person, to the vulnerable person, to the weaker person in that financial relationship. The law always is to the insurance company, you must have a fund that will satisfy Barbadians who purchase the risk of loss, who purchase an insurance policy. So that's the importance of statutory funds. I heard the Honourable Member for Christchurch East Central speaking of risk and so on and liabilities. But permit me to read what this legislation today is doing under the rubric establishment and maintenance of statutory funds. Section 25, subsection 1, the amending section, all companies registered under this Act to carry on long-term business or motor vehicle insurance business, or both, in Barbados, shall establish and maintain a statutory fund in respect of each such class or business, so that this one comes to the most ubiquitous of all the insurance policies in Barbados. I'm not sure, but if we have more motor vehicles insured than we have houses, I suspect we do, because motor vehicle insurance is compulsory, house insurance is optional. So I suspect that this is the most ubiquitous of all of the insurance policies in Barbados, motor vehicle insurance. And in relation to that, in relation to the motor vehicle insurance business, you must have this statutory fund. We have accidents every minute of the day, and there's some loss, if not to life, there's loss, there's bodily injury, and there's certainly property injury. And you always hear insurance companies complaining that people are not conducting themselves reasonably on the roads, and they don't do that because they're morally involved in people's safety. They do it because if people do not drive safely, they lose money. They have to pay out on policies. And so this one deals with motor insurance. Goes on to say a statutory fund shall be established at the date on which the company commences the carrying of either class of business. Again, statutory fund. You must have that statutory fund. And subsection 3, a statutory fund referred to in subsection 1 shall be established and maintained in accordance with any directives and guidelines issued by the Commission. Here again, Your Honor, is activity required of the Commission, activity mandated by this legislation of the Commission to ensure that that statutory fund exists, and of course that that statutory fund is viable. Subsection 4, a company shall comply with any directives and guidelines issued by the Commission in relation to the establishment and maintenance of a statutory fund. Again, the general point is made that the legislation moves itself away from a monetary regime and becomes an administrative regime in which the Financial Services Commission determines viability, determines how viable this company is, determines whether a company is able to pay its obligations under insurance policies. Again, I say, heavy responsibility, very heavy responsibility. I know that as a public official, the Commission with this responsibility is exposed to legal action by a consumer. Supposing, for example, an insurance company is unable to pay. Does the person suffering the loss sue the insurance company? Of course he sues the insurance company, but is he also empowered to join the Financial Services Commission as a second defendant, where he claims that that Financial Services Commission was negligent in relation to its duty to monitor the insurance company? As I said, sir, there's no monetary stricture placed within the legislation. It comes down to the discretion of the Financial Services Commission. So, unless the Financial Services Commission disagrees with me, they are exposed to civil liability if it is found that they fail to properly monitor the company. If, for example, they express the view that the company was viable, it goes to court, and the court, after inquiry, the evidence of actuaries and accountants and so on, and they find that the Financial Services Commission may have been negligent. I'm not trying to scare them, but they're exposed to civil liability for negligence insofar as that they failed to properly assess the viability of the company, insofar as they failed to establish that there was an adequate statutory fund. So this legislation, as I said, Your Honor, puts a very heavy responsibility on the Commission, and I take it that's the Financial Services Commission. I sum up by saying we move from financial or a regime that is monetary, and we move to a regime that imposes supervision that does not restrict itself within monetary limits. The old legislation, or rather the existing legislation, speaks to monetary limits. This amendment today speaks to the exercise of a discretion. Is that to invite danger? I don't know. What it does, though, as I said, it exposes the Financial Services Commission possibly to legal action being taken for it for the improper exercise of a discretion, and I go as far as to say for negligent supervision. So those are the two that were amplified in my assessment of this legislation. I take you, Your Honor, to Section 39 as well, which is interesting. Section 39 of the Principal Act is amended in subsection 1 by deleting paragraph G and substituting the following. Let us go, sir, to Section 39 of the existing legislation. This is the Principal Act, Chapter 310. 0 of the laws of Barbados. This is hardly a topic that is exciting, but it is no less important. So let us endure it. Now, today's legislation is removing paragraph G and substituting a new paragraph G. Let us come to what is being removed. I read, subject to subsections 4 and 11, every company registered under this Act shall, at the end of each financial year, prepare in the prescribed form and manner. And let us come to G. The company shall prepare in the prescribed form and manner, G, where the company carries on life insurance business, a certificate that the value of the assets of the life insurance fund exceeds the liabilities. 2, general insurance business, but not life insurance business, a certificate that the value of its assets exceeds the amount of its liabilities by whichever is the greater of the amount specified in subparagraphs 1 and 2 of paragraph B of subsection 1 of section 58. And 3, where the company carries on both life insurance business and general insurance business, a certificate that the value of its assets, including the life insurance fund, exceeds its liabilities by the amount specified in subparagraph 2 of paragraph B of subsection 1 of section 58. I do not pretend to be any expert in the area of insurance administration in this country, so that I do not know who becomes the author of that certificate. Those who have expertise in insurance will tell us who is the author of that insurance. But the law today, today's amendment, and this is not controversial, today's amendment shortens that. Here we have 3 instances of a certificate being issued on behalf of the insurance company as to its viability. Let's put it as simply as that, as to its financial viability. Today, this legislation says that a certificate signed by an actuary certifying that the company has maintained the solvency requirement determined by the Commission. So the other legislation, I don't know what had been or has been the practice in the insurance industry as to who authors that certificate of viability. That is my language. But the legislation today now says that the certificate is to be authored by an actuary, certifying that the company has maintained the solvency requirement determined by the Commission. So that today's legislation is specific. Today's legislation is quite specific. The existing legislation merely mandates a certificate without saying by whom. I don't know if it is done by the corporate secretary. I don't know. There are things that I do not know. I have no expertise in the area of insurance. But today's legislation says that the certificate is to be signed by an actuary. I'm not aware that there are a lot of actuaries in Barbados. Apparently only the brightest people do actuarial studies, and perhaps as a result, there are not many of them. But again, this heavy responsibility is placed on the actuary. I wonder if a lot of the actuaries that exist around here are not themselves connected to the industry. Certainly, I think most insurance companies employ an actuary, whether in-house or externally. But one would think that that actuary ought to be independent. He signs that certificate, certifying or verifying viability. But is he not supposed to do so independently of that company? Is he not also to certify that, as we say in law, that he doesn't have a bias? I don't know. I just wish that the legislation would have sought to guarantee the independence and the impartiality of the actuary. Like the judiciary, there always must be a guarantee of independence and impartiality. Perhaps the reality, the commercial reality around here is that it may be difficult to locate such a person. I don't know, but I wonder if it should not be a government official. I wonder if it should not be a government official. To say an actuary really exposes these circumstances or these arrangements to the possibility of biased assessment, to the possibility of a biased certificate. And I don't say that to offend any actuary in Barbados. You're seeking to guarantee fairness. And in guaranteeing fairness, you avoid bias. And you avoid, as I said, the possibility that there may be some direct or indirect relationship with the actuary who verifies. Now, obviously, if the actuary is working with the company, there's no question as to the possibility of bias, and you understand the law relating to bias, that it is not necessarily actuality of bias, but it is the appearance, it's the possibility. And in law, the possibility of bias is as wrong as the appearance of bias. The law treats them equally. In other words, the law seeks to create that distance between the judge, because this person is making a judgment, so that's why I say the judge. The law seeks to distance the person making this judgment, because he's issuing a certificate, he's certifying, and the law would seek to create a very wide distance between the person expressing this opinion, expressing this judgment, and if there's any kind of a relationship with the company, the law would fix him with bias. That's the term we use. It would fix him with bias. To entirely distance the assessor or the person issuing the certificate, I may want to suggest that it should be a government official, since in the exercise of its sovereign rights of the government of Barbados, the government has the power to intervene in these relationships, to intervene in any business, including insurance business. And if it is seeking to do that to protect the weaker party in the relationship, the consumer, if it is seeking to do that, perhaps the guarantee that justice will be done, is that you should have a public official exercising his judgment nevertheless, because the government official will be deemed to have no obligation, to hold no obligation to the company in private enterprise, to the company in the private sphere. So that is just an observation. I would prefer that the government relook that and be more specific as it relates to the person, the actuary, who certifies that the company has maintained the solvency requirement determined by the Commission. Again, remember, Your Honor, it is the Commission that determines solvency. It is the Commission that determines whether the company is viable. It is the Commission that determines whether the company is able to pay its debts, is able to pay its obligations under insurance. So that is the duty of the Commission. But the Commission's work is subject to the scrutiny of the actuary, because the Commission is not necessarily populated by actuaries. The Commission is obviously taking advice from accountants and actuaries and so on. And the legislation says an actuary. An actuary is, to my mind, too broad. It really is too broad. Who is this actuary in the private sphere who is given this heavy responsibility? Again, I say, sir, I would err on the side of giving that heavy responsibility to a public official. And if there is no public official, beg your pardon, sir, if there is no public official who is qualified as an actuary, what do? You go overseas. You go to one of the other Caribbean islands where you may find an actuary who is definitely not connected to the operation, definitely not connected to the company, definitely not, as we say, in a situation in law in which you describe him as a judge in his own cause. As I said, he's making a judgment, he's expressing an opinion, a professional opinion as to the viability of a company. If he's involved in that company professionally, whether directly or indirectly, you call him a judge in his own cause. And that is one of the principles of natural justice, that a man cannot be a judge in his own cause. A lot of people are not aware that the principles of natural justice apply universally to many relationships, and certainly it would apply in this event where this amendment probably collides against the principle of natural justice, that if you say an actuary, this legislation is exposing the commission to charges that it may have employed a judge in his own cause, that it may have asked an actuary, or it may ask an actuary to do an assessment of a company with which he may have some kind of professional relationship directly or indirectly, or in which he may have demonstrated biases. So I think this section is a little difficult. It's a little difficult, and I would hope that the government would consider it and, as we say, tighten it. Because ultimately, as the Principal Act says, what are we doing? We are seeking to protect the, let me read it again, sir. Yes. In the long title of this act, if priority is to mean anything, it says that this law is existent to strengthen the protection given to policyholders. Of all the things that this legislation does, there is a priority given to the protection of the policyholder, whether that's house insurance, car insurance, business insurance, public liability insurance. You're seeking to protect the policyholder, the small person in the relationship. And so that can travel as far as an assessment done by an actuary. Who is this actuary? Is he independent enough? Is he without bias? Or will he or she have a bias that protects the company in terms of certifying its financial viability? And I'm not saying that this would be done maliciously or with malevolence or anything, but it can be done negligently. We all make mistakes, but I would ask the government to draft this legislation in such a manner that it does not collide against the principles of natural justice. It may seem small. There was a case many years ago, Reed Diplock, a trust case in which the existence and language is important in the law when a judge comes to interpret a will, a trust document, and in that case, the placing of a comma in a sentence made pivotal difference to the outcome of the case, which resulted in millions of pounds being sacrificed by one party because of a comma. This is more than a comma here today, sir. If a court should be asked to interpret this legislation, I wonder if a court will not be invited by a lawyer. If a court would not be invited by a lawyer to define an actuary. Is it any actuary? Or, as I am suggesting, I'm proposing that it ought to be a government official or an actuary brought in from overseas, ultimately for the protection of the policyholder, who is the small person in the relationship. So those are my submissions as related to various amendments. I could just pause at section 58. An insurance company shall, for the purpose of the Companies Act, be deemed to be unable to pay its debts where it fails to meet the solvency requirement determined by the Commission. Again, that is the whole thrust of today's legislation, to remove itself from a monetary regime and to give a discretion to the Commission. Heavy responsibility on the Commission. I hope they do well with this new and heavy responsibility. But one, this legislation is exposing the Financial Services Commission to a lawsuit, to liability, possible liability on charges of negligent supervision. It's the Commission on charges of negligent supervision in the event, as we know, something seems quite often to go wrong in business. I was about to say always, but not always. Something often seems to go wrong in business, and that is why we have lawsuits, that is why we have the courts, that is why we have sometimes protracted litigation springing from these commercial relationships. So that the public will now be told, certainly by me, that this legislation, and not only the public, but the Commission will be told that this legislation now places a heavy responsibility. I am not going to use the word burden, but a heavy responsibility on the Commission. And can we say to the public that the legislation meets its primary responsibility to protect the policyholder? Or should we do as the previous regime, the previous legislative regime, should we go back to monetary limits, the safety of monetary limits? Should we be so daring, since it must be a daring act, since it is avoided, so it must be a daring act now to remove it? Could we raise those monetary limits and undertake that, perhaps by ministerial order, so that you don't have to come back to a parliament, give the minister power to raise the limits? Again, why? For the protection of the policyholder. Could we have considered that? Or shall we rest our hopes on a commission which is mandated to take a certificate from, quote unquote, an actuary? That is where we are, sir. Tempting as it was to respond to the less than technocratic contributions of the Honourable Member for Christchurch East Central, I thought not to, but maybe I would be breaching a similar political responsibility. I quote the Honourable Minister as having said, when they talk about debt, their decisions are costing Barbados today. The public may well be very disappointed with me if I did not remind the Honourable Member for Christchurch East Central that it is said with some credibility that this government has borrowed more money in this period than any other government. I repeat, it has been said with some credibility that this government has borrowed more money than any other government. That statement of the Honourable Members for Christchurch East Central found its way somehow into this debate, and maybe the public will be disappointed if I did not offer a direct response to it. So, Your Honour, this is a direct response to it. That by the nature of things, government is a continuum. And when a new government comes along, there is a sense in which it is a new party, but it is not a new government. As they say, the king is dead, long live the king. Government is a continuum. And if a new regime, if a new party in office finds itself with obligations, I suppose you can complain that you're trying to meet those debt obligations, you're trying to meet repayment. Of course, I would want to remind the honourable member that for the first time in Barbados' history, the government reneged on its debt obligations for the first time. So that when one is making these statements in condemnation, one must be wary of the glass houses in which one may live. That you accuse the last party in office as having burdened this administration with debt obligations, but you do not go on to say that this party in government has now borrowed more money than any other party in government. And for the sake of fairness and completeness of analysis, these condemnations must be joined by confessions. And that the time has come when these condemnations, when these accusations will lose what may appear to be their substance, when one remembers that the debt obligations of this government, certainly within the past year or the past few years, are now so heavy that the same condemnation that the honourable member makes of the last government can now be made of this government by a succeeding government. And one needs to remember that. One needs to remember that this government has no moral right to condemn with impunity, nor with immunity. That the wrongs of which you accuse the last government are compounded by way of commission by this government. To put it bluntly, we are borrowing money often, we are borrowing money almost monthly, and that mountain, that high mountain of national responsibility to pay will probably not fall on this government. And I wouldn't want to say it will fall on another government. I will say it will fall on people, the people of Barbados. And this needs to be said, so that these accusations of debt policy, poor debt policy, must not be made in a manner that shields this government from its moral responsibility not to repeat the same, and certainly not to repeat the same by exceeding those previous amounts borrowed. Let us as a country agree to that. Let this government, just permit me to say it, please. Let this government confess to the people of Barbados that these repayment obligations, in all likelihood, do not fall within the life of this government. That this government may be postponing this country's pain to future generations. And I would not engage in hyperbole, but but to a future generation. Since I'm not aware, speaking honestly, that the repayment obligations will stretch for generations, but they certainly will stretch well into the future. And so, I think the government needs to be more sober in its public discourse. I think the government needs to be more candid in its public discourse. I think the government needs to be more businesslike, to have a businesslike discourse with the people of Barbados, to be less alarmist about the past, which is the past, and to be sober about our present circumstances, and to say this government is in office. The government probably rejoices in the fact that not only is it in office, but it is in power. And there's a fundamental difference between office and power. And I would urge the government to return to the people of Barbados with a more frank discourse. And rather than looking back, invite the people of this country to look forward. Look forward a year from now, 2 years from now, 3, 5, 10 years from now, and say to the people of this country, what will be the consequences of the government's present escapade of borrowing? I can't put it any differently from that. It's an escapade of borrowing. It is, or an epidemic, if you wish. It's an epidemic of borrowing. And I don't speak with the authority of an economist. But being exposed to the arguments of economists, this government should not feel that it has to respond to a lawyer. I invite the government to respond to the economists. There are credible economists in Barbados, and I suspect that those economists who we will term public intellectuals, those academics and intellectuals who exercise the courage to visit the public domain of discourse in economics, I invite the government to speak with them, to incline this government's ear to their discernments, and to hear them say, not a lawyer, to hear them say that this government is putting this country in peril with the magnitude of its borrowing, and not to look back. As we often hear, what was done is done. If this government believes that it has corrected something that it says was done, let this government now say to a future generation what will be that future generation's consequences. And I'm not going to say that unborn. People who are born now, people who are living now, will have the burden beyond the life of this government. That is a discussion that I think this government needs to have. And that is a discussion that this government should not be having with itself among 29 persons in here, well, minus you, sir, among 28 persons in here. Let this government have that discussion with the people of Barbados, of a future generation. Let this government have that discussion with the economists in this country. I don't think they're mad. I don't think the economists are mad. They're trained. And I want to believe, and I know they know what they're talking about. And I know that they are outraged at the magnitude and the extent of borrowing. And to respond to another point, another statement made by the Honourable Member for Christchurch East Central, the member for Christchurch East Central justified the spate or the epidemic of borrowing on the need to have development. I challenge that. I say to the Honourable Member, through you, of course, sir, that this government has not been able to prove the development that ought to have sprung from its borrowing. The government has not proved it. We tend to hear of the loan, we tend to hear of the purpose for the loan, but in many cases, we do not see the development. The people of Barbados have not, in all cases, been seeing the development. And on that subject, if the government seeks to rescue itself in relation to that charge, in answer to that charge, that we hear of the loan, we see the loan, and we don't see the development. If the government wants to refer to the East Coast project, let the government come and tell the people of Barbados precisely what is happening in relation to the East Coast project. Will it fix this country with massive overruns? I ask some questions now. Is the East Coast Road project going according to schedule? Is the East Coast Road project being managed in such a way that it is progressing without fault? As I said, is it on schedule? Is it without fault? Or is work being done, and is that work being done in such a way that it has not been able, to use government's favorite word, it has not been able to sustain itself? In other words, is a lot of building going on in that East Coast project, and is that building sometimes collapsing? The people of this country need to know that. The people on the West Coast still have a vested interest that the East Coast work must be well and properly done on schedule, in accordance with, I think, the $264 million that was borrowed. In other words, what is happening on the East Coast? What is happening with the work being done pursuant to that massive loan undertaken? Or is that now in the realm of secrecy? Are the people of Barbados going to be told by this government, such as this government is obligated so to do? Are the people going to be told precisely what is happening with the money that they borrowed to fix the East Coast? I will not accuse anyone of negligence, but what I will do, I will ask this government to meet its obligation to report to the people of Barbados and to take that roadwork project out of the shroud of secrecy and make firm declaration. In other words, when will it finish? When will it finish?
Honourable, this is something to do with the insurance, right?
Yes, yes.
I just want to ensure that you tie it in
yes, indeed,
with the particular amendment relative to the Insurance Act, Honourable Member.
Yes. I was on the subject. Don't complain. Don't complain, Honourable Member.
Honourable Member, all I want to ensure that you do,
yes,
as provided for in the standing orders,
yes,
to ensure that what you are speaking is relevant to the amendment being sought by the act that is before this Honourable Chamber.
Thank you, sir. You will recall that I was responding to a statement made by the Honourable Member for Christchurch East Central, and I quote him, "When they talk about debt, their decisions are costing Barbadians today." That is what the Honourable Member said today on a debate on an amendment to the Insurance Act of Barbados, Chapter 3110. That is what the Honourable Member said. And in keeping with the standing orders, I reserve my right to offer a direct response to that statement. When they talk about debt, their decisions are costing Barbados. in relation to that statement, Your Honor, I respond to the honorable member and say to him that the debt incurred in relation to those roadworks is costing Barbadians today. That is all I'm saying. And I'm saying that in response to the honorable member's statement, I go further and I say that not only are the loans costing, like that East Coast loan, not only are the loans today costing Barbadians today, but they will cost a future generation tomorrow. That is all I'm saying. The original statement as to debt came from the honorable member for Christchurch East Central. And he went further and told this chamber and told this country, and I quote, the Barbados Labour Party has been the insurance policy for Barbados. So that the honorable member, by creative use of language, very creative use of language, managed to conflate a discussion on insurance with a discussion on debt, so that we are following the honorable member's intellectual creativity. He's a very clever man, very clever man. And so you will permit me, Your Honor, to respond to that creative intellect. The Barbados Labour Party has been the insurance policy for Barbados. He must be a poet in a different life. And I call that intellectual creativity. I am probably not as creative as the honorable member is. I know he blows a trumpet and so on. And in recent times, I've seen him singing. So he does have a creativity of which we did not know. But all I'm saying to you, sir, is that please permit me to respond to what the honorable member posited in here today. And let not the honorable member nor his colleagues be affrighted by constructive criticism. If you reserve the right to criticize the last government, please accept my right to criticize this government, and not to criticize this government unjustly nor unduly, but to criticize this government within the parameters of a debate in which statements have been made in condemnation, as I said, without the equal moral duty to confess to its wrongdoing. And so, Your Honor, that is my position, broadly speaking, in relation to today's amendment. I have offered what I believe is constructive criticism as to the drafting in certain material particulars. As I said, the movement away from monetary regulation to discretionary regulation by a commission. And then a possible collision against the rules of natural justice, the exposure of the commission to liability in a court. And that's nothing new. I mean, there's always exposure to liability. There used to be the exposure of the supervisor of insurance when there was one to liability. So it's nothing new to keep the debate candid. And that section in which it speaks too vaguely as to the invitation to an auditor to certify a company's...
Actuary, Your Honor.
Beg your pardon, sir?
Actuary.
Actuary, thank you, sir. I beg you, yes. I'm so obliged to you, sir. An actuary to verify. I repeat, before I say, I invite the government to make that actuary a public official, and at the same time, to make that public official an actuary. and not to expose the lady or the gentleman actuary to possible judgment in his or her own cause. You've been very kind, sir, and I'm obliged to you.
Honourable members of Microsoft Central.
Thank you, Mr. Speaker. Sir, as I rise, I'm smiling, not just because I am very happy to welcome the Honourable Member for St. James North, but because I was at risk of getting completely lost in that meandering stream of consciousness that we were just subject to. I mean, really, my laughing now is almost bordering on delirium from having experienced that quote-unquote presentation. So many ifs and conjecture about things that collide not at all with reality in the legislation. If my grandmother had wheels, she would be a bicycle. I mean, you could say if about anything. That cannot be the basis for a reply or for an assessment of a piece of legislation, but I will come to that, sir. I cannot come to my feet on this occasion without officially registering my congratulations to the Honourable Member for St. James North for being with us in this honourable place today. You know, around 2017, 2018, when we were many of us were in pursuit of the achievement that the Honourable Member has now met, he supported many of us in that pursuit. And I recall making a call to this person that I was just meeting and just hearing some of his thoughts and ideas for the development of the country, and asking him to speak at one of the meetings in my constituency, and he came right away, and he spoke impressively. And what many people outside of St. James North may not have yet discovered is that after he spoke creditably, then he was ready to lime extensively, which is also a part of engagement. Also ready to listen closely. For those of us who were with him over the last month or so, one of the things that you will observe is that once he is speaking to a constituent, you cannot interrupt him. His focus is complete. And so I had to take a couple minutes, sir, to be able to speak to the character and the focus of the person, and to officially welcome the Honourable Member to this place. Sir, you know, it is difficult for me, and this does not happen often, to even begin to frame any kind of reaction to the member who spoke before, the Honourable Member who spoke before me. To hear the words in an intervention, "This is more than a comma," in response to two words in an amendment, the two words being "an actuary," really tells us that we have gone beyond the pale. The fact is, sir, that these amendments do something that modern legislation increasingly is doing, which is helping to shift the burden of reporting and of accurate reporting to the companies, to the private sector, to be able to make sure that beyond having static limits for statutory funds, that the kind of information that is reported by these insurance companies, how often it is reported, the categories of data, all of those things lend to the commission, the Financial Services Commission, being able to monitor in an ongoing way what the levels of profitability, the nature of assets, and so on that are reported as a part of the insurance business being carried out by this company. Shifting the burden of accuracy and accountability to those in the sector is nothing new. Being able to govern or to monitor by guideline, the central bank does it all the time. Not everything is prescribed in regulations or in legislation. Other financial institutions that are tasked with governance and are tasked with surveillance and supervision do this all the time. Issue from time to time guidelines to be able to control or to perform surveillance on the activity of the companies or the banks and so on that they supervise. And now we are being asked, having been told that there may not be any credible actuaries in Barbados, I don't know where that has come from, because there are several. Now we are being asked, now this is a bit of a pivot now from saying we're bringing in too many people. Now we're being asked to bring in people to perform a function that is done every day. It is no different from an accountant preparing a financial statement on behalf of a company that then becomes subject to surveillance, or then becomes subject
Your Honor,
to...
Your Honor, may I raise on a point of order,
What is
please?
the point of order?
Yes, I think the honourable member is misleading the chamber when she misquotes me as having said that there are no credible actuaries in Barbados. I don't believe you heard me say that, sir. I would have said that there are actuaries in Barbados, but always the possibility maybe that they have a direct or indirect relationship with the company. I would not want it to go abroad, whether by mischief or by accident. To hear the honourable member say that, I say that there are no credible actuaries in Barbados. In fact, I went on to say that the actuaries tend to be very bright people, except that it may be difficult, and that they're so bright, so there's few of them, few people who do actuarial studies in Barbados. And that I said that because the numbers may be so small, the numbers of actuaries are comparatively small in relation to other professions, that you may have to find that it is difficult to find one who is not directly or indirectly related to the companies. I'm obliged to you, sir.
Continue, Honourable Person.
Thank you, sir. I
Consent.
will not spend too much time debating this, except to clarify that I did hear correctly. The notion that because this is an area where people are so bright that you don't tend to find many in Barbados, I don't know what that means to tell us about the level of intelligence of Barbadians. I was reporting exactly what I heard, and Hansard will bear me out. But I move on, sir. And the fact is that actuaries, accountants, people that work in financial services are in the habit of preparing financial statements and records on behalf of companies as a part of their professional duty, and indeed keeping to a certain professional standard. Just as lawyers are meant to, just as any other profession is meant to. And so the fact that one, and I'll get into a little bit more into why we are seeking to move to a regime that is more flexible, but I would not want for Barbadians to believe that it is impossible to find an actuary without some tie to a company. The actuarial services that are provided to companies are just as regular as any accounting services or legal services or any other. It happens in Barbados every day. And so I set that aside, sir, as quite frankly, not even worthy of a further discussion. Sir, the fact is that these amendments to the Insurance Act become necessary because of the constantly evolving insurance industry and really the overall investment space in which we find ourselves. We have seen, and we've experienced it in Barbados, that there are all kinds of new products coming on the market. There are all kinds of differentiated services coming on the markets, and increasingly, borders are being removed more and more. When it comes to international financial services, which in fact has been one of the areas that has contributed to the tremendous growth here in Barbados over the last 3 decades. More and more, this is becoming internationalized. We've seen just recently the establishment of an insurer here in Barbados whose insurance products are related to blockchain technology. We are seeing more and more with our interest in and our need to have concerns about the climate crisis, that there are all kinds of climate-related insurance products and all kinds of climate-related insurance questions. We've seen that there are new carbon market platforms where carbon pricing and the sale of carbon credits also now necessitates a completely different accounting and insurance framework. And so every day, new products are being created, and it means that the existing legislation that simply sets a dollar amount in terms of statutory funds that must exist for these very prescribed products no longer serve us. And the Financial Services Commission needs to have the flexibility to be able to issue guidelines and to be able to allow the industry to become compliant internationally with some of the new requirements that have been established. So we see more and more that companies are being asked to make climate-related disclosures that have to do with the risks as well as the opportunities that are being created in the context of the climate crisis. Companies are being asked, and investors are being asked to quantify physical risks. They're being asked to quantify transition risks. And transition risks relate to what are the financial and economic and human costs of moving towards a low-carbon economy? What are the kinds of products that now are being created? How are we able to keep monitoring the kinds of risks that are now being created, not just in the particular jurisdiction, but in neighboring jurisdictions? Because as we heard as the Honourable Member for Christchurch East Central, the idea of insurance has to do with pooling risk and being able to diversify your exposure to some of those risks. And so this is not the old market that we're used to. Even in terms of life insurance models and types of products, there are all kinds of different products that are being offered now. And so it means that the Financial Services Commission has to follow the rest of the world, because again, this is an international sector. Investors are diversifying their exposure to risk by putting some investment in this market versus that market. I understand the risk that I face in Barbados, and I am going to hedge that risk against being able to invest in Curacao or in Trinidad and Tobago, in different sectors, in different geographical areas. That is the nature of the sector. And it means, therefore, that there need to be internationally comparable standards for the data that companies are submitting in order to be regulated by the Financial Services Commission. So it means, sir, that there's now a reduced emphasis on these very specific rules that are going to be enforced by the regulator. An increasing emphasis, I mentioned earlier, shifting the burden, increasing emphasis on what are the governance structures, what are the reporting guidelines that mean that the institution is able to follow good financial practices. And that's what the Honourable Member was referring to. The Honourable Member for Christchurch East Central was referring to when he talked about a move towards risk-based supervision. So we understand what risk means and looks like. And one of the reasons that this is so important for our market is that Barbados struggles itself with the idea of quantifying risk. Barbados often, as a market, as a country, often has to be a part of conversations with other countries, with international financial institutions, to give them an understanding of the real risk that their investments face, because often we're painted with the same brush. And a part of our job is to be able to help the market, through the data that we collect, adequately quantify the risk that they are really facing. And I'll tell you a little bit further what I mean, sir. There are those who believe that every country in a particular geographical area faces the same kinds of physical risks from climate. And we know that's not the case. We know that some of those risks can be offset by good governance, by investments in adaptation, so things like sea defense walls, and other kinds of investments to mitigate against investment loss. And so we, as Barbados, have to be able to frame and tell the story about what is the true risk that is represented in different sectors in which you invest. So, sir, it means that for an insurance company that is planning to introduce a new product, the focus cannot just be on what is the quantum of resources that you've set aside, but it has to be on whether the insurer not just has sufficient capital, but whether the way that they're collecting information, the way that they're categorizing assets, the kinds of supervision they themselves are involved in, are going to allow them to adequately manage current and future risks. Sir, in 2017, the International Accounting Standards Board introduced something called IFRS 17, the Honourable Member for Christchurch East Central made reference to, the International Financial Reporting Standards. This is in 2017, and they were meant to come into effect from 2021, but eventually, because countries and companies had to prepare, they determined that these would come into effect, I believe, from the beginning of 2023. And it gives a bit of an indication of how the industry is changing and why these changes are necessary. So, for example, under the old IFRS, IFRS 4, which was established in 2004, companies were measuring insurance contracts using historical information. We suffer from that, sir. We in Barbados suffer from that. We suffer from being assessed on old measures of GDP. So you know what that's like. You can't really have a dynamic economic response or economic assessment if you are measuring based on old data. And so under the new IFRS 17, companies have to measure insurance contracts at current value. Companies have to consider the value of money, the time value of money, when it's estimating payments to settle claims. Companies have to measure insurance contracts based on the obligations that are created by those contracts, so that companies have to be able to report more clearly on their profitability. These are the kinds of changes and the kinds of reporting that have now become necessary for markets in Barbados and for companies in Barbados. The application of consistent accounting frameworks across all jurisdictions. So this IFRS 17 is really the first international accounting standard that applies to all countries. Before, countries were allowed to have their own standards. So it means that I'm comparing apples and oranges. If I have an investment in Geneva, I can't compare it with my investment or my accounting standards in Barbados. It means, sir, that I can't compare among industries. I can't see how my investments in green technology are doing against investments in infrastructure. So, sir, it is a way to modernize the insurance market such that people are better protected, such that there is reference to and an eye to what are the current risks of any new products that a company is getting involved in or attempting to sell to people, the extent to which they will be able to cover any payouts from those new products, and being able to also monitor the governance arrangements in place to make sure that those companies, it's not just about having a set of money that you put aside, but given the day-to-day risks that keep changing every day, is that stock of money enough to cover everything that you might face, enough to cover any call that a client may make on the insurance contract that exists? It is an evolving way to better protect Barbadians who have insurance contracts with companies, increasingly with products that that are new and that are not traditional and that don't have a legacy or a track record in the market. So the fact is that in most mature economies and in most developed countries, insurance liability and responsibility is spread more evenly between the private sector and the public sector. In fact, in most other economies, the private sector carries more of the burden for insurance. That is one of the reasons when we have the climate conversation, we talk about the possibility of wipeout risk. We talk about the possibility that if something happens that completely devastates the country, not only is the country at the individual level grossly underinsured, but we had to build over the years the capacity for the state to make up for that. One of the reasons that we have made such a noise about this issue of loss and damage and wipeout risk is that we don't have as mature an insurance sector with as much coverage as you will find in other jurisdictions and in other countries. So when a hurricane comes in one part of the US, the private sector insurance is such that it is sufficiently spread and the event to which they're responding is sufficiently small that they can respond immediately. In our part of the world, our single small island hit by a major extreme weather event is more likely to be able to have been devastated completely. And that degree of loss cannot be covered by any regular insurance. Conversations about insurance as an instrument to protect us are long overdue. And conversations about the way in which insurance as an instrument can protect individuals is long overdue. You know, we are at the start of another hurricane season. And the fact that we are hearing still about the underinsurance of individuals with respect to homes and other assets is worrisome. The state, the country, the government has pledged to make sure that no Barbadian is left or no resident of Barbados is left out in the cold in circumstances where an event has happened, has taken place, that could not be helped or could not be controlled. But as the Honourable Member for Christchurch East Central alluded to, there is also a role for each of us to play in shoring up the homes that we have in advance, but also in having access to adequate insurance instruments. Now, access to adequate insurance instruments is itself a conversation. To what extent are we able to create instruments to which people find affordable and which people find valuable? That remains an ongoing conversation, but it has to be part of the conversation. It is the same way in which risk related to healthcare have to be part of the conversation in the health financing discussion. Because I recall that back in 2017 or so, we started to discuss the idea of a wealth for health instrument, meaning that if you are exercising, you don't have to go to the gym, you could walk, you do some push-ups. If you are exercising, if you're moving your body, if you are eating well, and I'm not going to go into what eating well means, because there's some of us that think that eating well means buying a $12 protein bar, which is really just fake food anyway. But what the instrument that we discussed at the time had to do with ensuring yourself with the things that you have control over. So that if we can tell, for example, with someone who's on a particular treatment protocol for an NCD, who is following the treatment protocol, who is doing their best to monitor and control their eating habits, and who's moving their body and other markers of health care, that rather than having to pay on the treatment side, that we pay in advance for the fact that you are reducing your risk and therefore reducing the potential cost to the state of having to care for an individual once they become ill. Sir, I raise these things because this is not just an academic exercise. This is not just a question of changing from a statutory fund to a more flexible regime. This is about how do we secure the well-being of Barbadians, not just with respect to their living conditions, the homes in which they live, the assets that they hold, the small farms that they have that help feed their family that will be wiped out in an extreme weather event, their health care and the way that they live, their investments and the way they plan their estate so that they can leave something for their families. These are the kinds of conversations that we need to be having, and this legislation starts to take us towards a more accessible insurance framework and regime where people not only realize that insuring ourselves, not just with insurance instruments, but with the things that we do every day, not only is that important, but that the state has a responsibility to protect clients of insurance companies in a dynamic way, because this is an industry that is constantly changing. Sir, there are many questions to consider when we talk about resilience. And sometimes we get into this idea that resilience is something that you fly overseas and talk about in a boardroom. The fact is, sir, that as the hurricane season begins, when we come to consider the quality of the housing stock and the extent to which people are able to access finance to secure themselves, all of this is a part of that conversation. The new kinds of instruments that are being created have to be able to create some kind of revolving fund, some kind of access that is contemplated through the catastrophe fund, to be able to make these kinds of things available to Barbadians. Because unlike other jurisdictions where the private sector overwhelmingly comes in to respond in circumstances where people find themselves exposed, increasingly small developing countries like Barbados do not have that private sector capacity because of the undersaturation of the industry. And therefore, it falls to the state through its regulation in advance, and then we hope that we will not have to, but then after the fact, by being able to come in and play that role of being able to rebuild and make sure people are properly recited and are able to get on with their lives in the event that there is some major weather event. This legislation relates and will tend to relate mostly to the kinds of insurance products that we already have in existence. Life, motor vehicle, the kinds of things that Barbadians tend to already invest in. But the point is that increasingly that profile is changing. Increasingly we are seeing different types of insurance products, different types of insurance models. We want people to continue to invest or to begin to invest in this kind of insurance. I think that there is still a role to be played to be able to settle an affordable insurance model for most Barbadians. But we know that often people tend to value the money they have today and see less of the value of money that they invest now for later. But increasingly, all of us in here who represent people know that if we do not plan adequately for the lives of the loved ones that we leave behind, that the assets that we have worked hard to build increasingly will lose value. I don't need to talk too much, sir, about the homes or the buildings that we pass that have become derelict. Mainly because we have neglected to adequately indicate to whom should they pass or under what circumstances. Equally,
Your Honourable Member has 2 more minutes.
I thank you, sir. Equally, there's also scope to be able to make less burdensome the requirements of being able to prove succession or to be able to handle the estate of a deceased person once that person has passed on. These are the kinds of things that cost, that we end up losing assets, we end up losing the assets that our hard work have created, we end up being unable to pass them on because we don't have the wherewithal to, one, do the planning, and then to have administered the letters of administration, the wills that go through probate, all of these things that increasingly people find inaccessible and unable to be navigated. This, sir, is a single discussion. It is about these very necessary amendments towards this risk-based system that keeps people protected, but it is also, as part of the conversation, about how we protect ourselves, the work that we do to make sure that while we are here, we are protected, and that when we are gone, our loved ones are able to benefit from the legacy that we have left. Sir, I'm obliged to you.
Honourable Member for St. James North.
Thank you very much, Mr. Speaker. I rise, of course, to support the amendment before us as outlined by the Honourable Member for Christchurch Central. And I use this occasion to firstly thank my colleagues for their remarks, welcoming me to this House. But in my intervention, Mr. Speaker, I just very briefly want to treat to a few things. Firstly, that when you look at where this jurisdiction continues to go, particularly in the context of investment and ensuring that the jurisdiction continues to be fit for purpose for both local and foreign investors, and ensuring that the world understands that Barbados is serious about business, whilst equally at the same time ensuring that we can ensure that the resilience framework necessary for business and doing business, and in particular in the insurance market, is critical. We therefore can see why this amendment is necessary. As you've heard, and I agree with my colleague from St. Michael, the Honourable Member for St. Michael South Central, that the global reality is that Barbados as a jurisdiction continues to compete amongst many other jurisdictions of a similar class. And therefore, the amendment, to my mind, takes into account the changing realities of the insurance sector. There is no secret, of course, that Barbados, like many other small island states, continue to be on the front line of the climate crisis, and therefore the risks that come with that continue to increase. And we have to be in a position that when new modes of insurance come to the fore, with new products constantly coming online, that we have to offer that level of protection for our beneficiaries, and equally a regulatory framework that is robust enough that still puts the jurisdiction in a place that will continue to attract the best and innovative products that can come on stream. And therefore, it allows for greater certainty in the market. It allows for, as I said, both domestic investors, foreign investors, who also consider the changing landscape when they're making their decisions in their boardrooms across the Caribbean and the world, to see Barbados as that jurisdiction that allows for certainty, that allows for innovation, and that allows for them to be able to do business with the country, particularly as the government builds out its capacity in attracting new modes of business, new products, and in particular within the confines of the international financial services market. And I therefore want to very briefly speak on the issue, as I've just spoken about, not just resilience, but the issue of capacity. Because earlier, we would have heard, Mr. Speaker, the issue of capacity, but in the context of debt. I go there because it was our Barrow, the Right Honourable our Barrow, who, in his wisdom, and of course, we must remind the public, our Barrow, of course, is no secret, was the founder of the Democratic Labour Party, which the leader of the opposition is now at the helm. Of course, he may not be of the same ilk, but he's now at the helm nonetheless. And I say so, cognizant of the fact that our Barrow stated that any small island developing state, particularly in the context of the Caribbean, Mr. Speaker, has within its purview a number of options. But those options require small states like Barbados, particularly in the Caribbean, that from time to time, you have to go to the debt market to be able to furnish and do what is necessary for the development of your nation. And we must remind the public and those in the Democratic Labour Party who want to listen, and I understand that listening is not their strongest asset, but suffice it to say, the Democratic Labour Party, Mr. Speaker, is in no position to lecture, teach, admonish, or any other phrase you want to put there, the Barbados Labour Party or the public of Barbados on the issue of debt restructuring, and the capacity thereof. And I start there because my colleague, the Honourable Member for Christchurch East Central, at the onset of this administration, when the people of Barbados said in their numbers, and it's so interesting, Mr. Speaker, because the leader of the opposition at that time was of our view. But sometimes in life, things happen. But we must remind the public that the Honourable Member for Christchurch, East Central, and the team that is currently administering governance in this country took over a nation that was on the brink of economic disaster. Not just were we on the brink of economic disaster, but had that intervention not taken place, the social impact of Barbados would have been significant. And we must remind the public that we were weeks away from paying an astronomical debt, but had we done so, given the fact that we had little foreign reserves in the kitty, as it were, it would have spelled total economic disaster. The Barbados dollar, which we need, and the preservation of the peg, which we need, would have come tumbling down, and the economic and social ramifications would be unimaginable. We therefore, doing the responsible thing, had to go to the international financial community and say, look, yes, this is not our fault, but we weren't elected to point fingers. We were elected to govern, and govern we did. Lest we forget that under the Democratic Labour Party's leadership from 2008 to 2018, our country became a country not just that was borrowing excessively, and that's what makes it so interesting, Mr. Speaker, the irony and the arrogance to try to lecture a party that has saved this nation from disaster. They borrowed so much with little to show, no garbage trucks, no buses, cutting of tuition fees, all the sorts, garbage flowing on the streets, the social infrastructure, the physical infrastructure, under total decay, nothing to show. But yet, as a result of the economic mismanagement coupled by the borrowing that they did, led us to be the third highest indebted nation, not in CARICOM, Mr. Speaker, not in Latin America and the Caribbean, but in the world. I repeat, Mr. Speaker, those who have ears to hear, let them hear. And this administration that I'm proud to be a part of will not be lectured by anyone who sees it fit to try to mislead the public in circumstances where we've now come out of the situation, having gone through pain as a result of the mismanagement of the Democratic Labour Party. Mr. Speaker, you will recall that during that time, 2008 to 2018, our country was the laughingstock of the world economically. 23 downgrades. 23 downgrades, Mr. Speaker, is no slight thing. It therefore meant going on the capital market to borrow was even more expensive, because why? Barbados had reached junk bond status. Nobody didn't want money at all. Nobody didn't want to give us any debt at all. Barbados' economy under the Democratic Labour Party was pot down. And this administration, the Barbados Labour Party, led by Prime Minister Mireille Motley, and the Member of Parliament for Christchurch East Central, and all of my colleagues in the Labour Party, rolled up their sleeves from day one, put their hand in the economic quagmire that we had to face, and went to work. We went to the International Monetary Fund. And as we say, the rest is history. We've not only not had downgrades, but we've had upgrade after upgrade after upgrade after upgrade. Barbados' economic rating now is one where it's the pride of the Caribbean and in the Western Hemisphere. I remember my days in Geneva, and the Honourable Member for St. James South would recall when she would travel to Geneva from time to time, you would hear the same thing. Barbados was laughed upon in the early stages. This is the real, it's nothing to be proud about, but it is the fact because persons had so become used to Barbados punching above its weight that the disastrous administration of the Frandell Stewart era led us to become, as I said, the third most indebted nation in the world. At the time, Mr. Speaker, at the time of assuming leadership of the country, 2018, they talk about debt and borrowing. Mr. Speaker, debt, when we came to office, and you have to put debt in its perspective. It is not just about how much you borrow. It is about the country's capacity to pay back when you borrow. Hence the debt to GDP ratio. When we came to office in 2018, the debt to GDP ratio was 178.9%, Mr. Speaker. 178.9%. So those of you online, if you want to get out your calculators, come, go ahead. They borrowed excessively for 10 years. Not a bus, not a sweetie. Well, we didn't get any sweeties, but we all knew who was getting these sweeties on the other side. But the public was not the beneficiary. And of course, the government said, in order to stabilize patient Barbados, we will bring down the debt to GDP ratio to not only stabilize the economy, but to bring back certainty to the markets so that both local and foreign investors can come to Barbados again and do business. Of course, we had COVID, so therefore we had to go up a bit because we had to borrow to stabilize and to bolster the economy. But even then, we were some 40% less in terms of the debt to GDP ratio than when we took it up in 2018. And we all know that COVID was a disaster for the world. But through strong economic management, discipline, and focus, this administration has been able to bring down the debt to GDP ratio while still borrowing, and we can see what we're borrowing things to do. Buses, as I said, trucks, the infrastructure, building out the capacity, not to pay wages, but to build the capacity of our economy. It is now down to 102%, Mr. Speaker, sir, 102.8% to GDP. Now, let's face it. On the one hand, Mr. Speaker, you have the Democratic Labour Party that was borrowing left, right, and center for 10 years and left the debt to GDP ratio at 178.9% to GDP. We were in an IMF program, still doing things on behalf of the public, still give the public salary increases, Mr. Speaker, building capacity, and brought down the debt to GDP ratio to 102.8%. And from all economic indications, we are about to cross the 100 barrier down into double digits as well. Now tell me, Mr. Speaker, any reasonable thinking person out there can see, not only can they see, they can see, feel, and understand that this administration has not only saved the Barbados economy and the dollar, not only have we reduced the debt to GDP ratio, but that we are on an onward trajectory for further growth. And I understand, if my memory serves correctly, we've now had 15 consecutive quarters of economic growth. So therefore, I just wanted to quell a lot of the fake news that we continue to hear. And I understand it. If a country and an administration is performing admirably, particularly when it comes to economic development, you try to create a lot of noise and untruths. But let the record reflect that this administration, and credit has to be given to my predecessors also, when I was wearing the hat of Minister of Economic Affairs, from the Honourable Member for St. Michael South Central. Fast forward to myself, and now the Honourable Member for St. Philip West. Anchored, of course, by the Honourable Member for Christchurch East Central. This administration, not by our indicators, Mr. Speaker, but by every global indicator, regional and international, has put Barbados' economy, its stability, its investment climate on a trajectory of growth, stability, and certainty. And I want to once again reiterate my support for this amendment because it places Barbados' capacity, resilience, and forwardness in a way that will redound to the benefit of all. I thank you very much.
Honourable for Christchurch East Central.
Thank you so very much, Mr. Speaker, and let me thank honourable members for their contributions this afternoon. I will be brief, sir, but I need, for the record, just to respond to the Leader of the Opposition precisely. But before I do that, sir, earlier in my presentation, this was just after you warned about looking at your cell phone, sir, so forgive me. I stated that the amount that we pledged for the OECS was 18.5 million. It was actually 37 million, sir, and not 18.5. And I state that, sir, because the honourable member in his, or I should say the honourable Leader of the Opposition, sir, in his quest to respond politically to charge that this government has been borrowing and borrowing and borrowing, sir, and I made that reference, sir, specifically located in the context that the previous administration pledged support from the taxpayers of Barbados for an insurance matter, and that the government had to resolve the matter, meaning taxpayers had to pony up money, sir, to resolve the matter of an insurance nature. And therefore, given that he opened that avenue in his response, and let me just say for the record, sir, again, as I did in the budget, because they keep referring to how much money we borrow, but not how much money we've actually repaid during that time. But I'm going to locate it again in the context of why I raised it, sir, because we have borrowed $1.635 billion, $39 billion, sir, since June of 2018. Until the end of March this year. And the honourable member for St. James North brought some students here this morning with him that I'm sure that they're more than capable of doing a very simple calculation, because the total monies that we pledged to resolve CLICO, sir, was $451 million, sir, 451 million. If you divide 451 million, sir, by 1.6 billion, sir, you will get approximately 27.5% of the debt that they refer to that we had to resolve the matter in relation to CLICO. And therefore, I raised that particular point because this matter of insurance, sir, how the regulations are enforced, are important to understand that a government does not just take up taxpayers' dollars and pledge to bail out, sir, private entities, particularly, sir, private entities with some association to those in George Street. And I was very at pains to listen to the honourable member in his submission, because he went through every clause in the bill, sir, except the last one. The last clause, and I should read it in to the record here because he did not refer to the last clause, sir. Clause 10, dividend not to impair capital, sir. 150, no dividend shall be paid by any local company while its assets are less than the amount required for solvency as determined by the Commission, sir, pursuant to Section 58, nor shall any dividend be paid that would reduce its assets below the same amount or impair its capital. He went through the entire set of amendments, sir. You recall, and he made no reference to that. You know why he made a reference to that, sir? Because when CLICO was in trouble, sir, executives in this country were removing funds from CLICO, sir, to their own benefit, not the policyholders, sir. And therefore, do not come here to lecture the government about regulations. If these things were in place properly so, I said in my presentation, perhaps, we would not have had to be exposed in the way that we were exposed. So the honourable member would be gentlemanly if he would not try to trouble me, sir, when he gets up to take the floor. Let me also respond to the nature, the query about the actuary, sir. Most life businesses, sir, and it's particularly life businesses, most life companies would have what you refer to as a resident actuary and an appointed actuary. Two different actuaries, sir. The resident actuary works for the company, inside the company, sir. Pricing products, liaising with the regulator on queries that the regulator may have about the products that the insurance company is bringing to the market, and doing that nitty-gritty work, sir, with the regulator on a day-to-day basis. The appointed actuary, yes, whilst paid by the company, effectively serves as the external entity that is validating the internal works being done by the resident actuary and the team, who then will sign off, sir, that the things that are being done within the context of the company supports that which the resident actuary is doing. And each actuary, qualified, they have a fiduciary responsibility, because it's like an engineer, sir, looking at the beams in this building here and certifying that the beams in this building are fit for the loads and everything, sir. An engineer has a professional responsibility to do that. In this case, sir, the actuaries, whether resident actuary or the appointed actuary, they are the ones who professionally, sir, will certify that the things that the company is engaging in meets the associated risk with respect to the operation of the entity. Now, whilst the Financial Services Commission would dearly love to have an actuary on staff, which we have in relation from a consulting perspective, the reality is that the industry continues to evolve, and if there are any Barbadians out there interested in working, qualified Barbadians, that is, sir, interested in working with the commission, they're happy to approach, because as you would appreciate, there are different types of business, people have different types of expertise, and certainly as it relates to the implementation of IFRS 17, that type of experience is important with respect to the commission being able to ensure that it has the capability to be able to respond in the marketplace. But the professionals, sir, the actuaries, those working in the companies, they are the ones, sir, that they have to sign. They have to sign to say that these products that we are offering, we've tested them, they meet the regulatory standards, they protect the policyholders, they provide appropriate level of risk in relation to what happens with the reserve, sir, and that is their job. That is their job. And therefore, the commission, in providing the necessary regulatory oversight, will engage professionals to be able to validate, sir, validate what is being presented on an ongoing basis with respect to submissions from insurance companies, in order for the commission to, as part of not just the stress testing that we have regime that we've put in place for insurers, but equally, sir, as you could appreciate, we have been working collaboratively with the central bank as well, sir, because some of the insurance companies are particularly large relative to the jurisdiction, and therefore that oversight is effectively in place, working, those two institutions working together to look at whether any particular systemic risk may exist that we may need to be concerned about. And so far, sir, notwithstanding the CLICO matter, the system is held reasonably well, and notwithstanding the fact that we do know that investments were stalled in the country because financial flows had diminished because of the demise of CLICO and the 10 years or roughly that it took to get it resolved, that had a significant impact on the economy. And that is why, sir, even if something goes wrong, the time that it takes to resolve these matters, we've put measures in place to make sure that that can be shortened, because there's nothing like financial uncertainty, contagion, sir, that has, there's nothing that has a more negative, impact on the economy, sir, than contagion. And therefore, it's something that we have been working to ensure that we enhance the surveillance. But if something happens, sir, the intention is to make sure that between the court system, sir, and the regulators, that you have an expedited approach to being able to resolve these matters quickly so that the uncertainty would not be there. And so, Mr. Speaker, I hope that with these amendments, we will start to see a level of innovation within the insurance industry that, as I said earlier, is appropriate to the risk profile. One of the areas, and I know the Honourable Prime Minister and the member for St. George South, they have been working with those in the housing sector, sir, in relation to being able to unlock opportunities for investment in terms of Barbadians and getting mortgages. The target really, sir, is to be able to reduce the time it takes to get land conveyed and mortgages through the system from 6 months down to either 7 or 14 days. And one of the things that could very well impact that is where insurers potentially, sir, introduce title insurance as a new product, which will protect both the financial institution as well as the prospective buyer in relation to any particular claims that could be outstanding. And the truth is, sir, is that once we can get things like that in place, it means that ordinary Barbadians, sir, rather than having to wait 6 and 7 months, sir, and you know, sir, the documents go from one lawyer to the next lawyer and everybody waiting, sir, to get all of this thing in place, all the I's dotted and the T's crossed, which still have to be done. But the introduction of title insurance, sir, will short circuit a lot of that, and we'll be able to get Barbadians into homes faster. And therefore, it's something that I think as we do more, well, I say we, government working with the stakeholders, being able to educate Barbadians as to why these new types of products could revolutionize not just the housing sector, but generally speaking, the economy, the ordinary Barbadians then will be able to see that things can happen faster. And once things are happening faster, sir, then I'm confident that not just that people will get work, but people will be able to get into their homes sooner rather than later. Particularly, sir, since we're living in a world where the introduction of tariffs or the threat of tariffs every day causing costs to go up. And therefore, 6 months can make a big difference in relation to the cost of you being able to build your home. And therefore, at that very local level, we will hope that these types of products can be introduced quickly with respect to this type of thing. And I say so, sir, because as I'm advised in the colloquium that was held with the Prime Minister, it was noted that over the course of the last 40 or 50 years, sir, the number of fraudulent instances, less than 0.5%, sir. And therefore, that is good risk to insure to allow people to get a speedier process through the exercise. So financial institutions will be protected. Owners will be protected in that context. But what's the most important, sir, is to get through the process as quickly as possible so that people can mobilize their resources, get their homes constructed, sir, and to be able to move forward, I think, in earnest. And I think that with this type, so whilst we didn't speak, I didn't speak specifically about the impact that these amendments will have. I think in that particular instance, sir, I think we will be able to unlock ownership faster for Bajans with these amendments. And so, sir, these are important for the future of Barbados. They're important for the future of Barbadians being able to get access to land and home ownership in this country. There are a range of other innovations that will come on stream in relation to these amendments. But I look forward, sir, to seeing this bill pass not just today, but in the Honourable, in the Senate, and to allow Bajan, sir, to be enfranchised and for us to move the economy forward quickly. And so, sir, with those very few words, I beg to move, sir, that this bill be read a second time.
Beg the second.
Question is that the bill be read a second time. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that you do not leave the chair and the House resolve itself in the committee for further consideration of this bill.
The question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
This Honourable House is now in committee.
Mr. Chairman, may we take the clauses in parts? Breaking it down in parts?
Yes, sir.
Clauses 1 through 5.
Mr. Chairman, I beg to move that clause 1 to 5 stand part.
The question is that clauses 1 through 5 stand par. All honourable members in favour, say aye. Honourable members against, say no. He thinks the ayes have it.
Clauses 6 through 10.
Mr. Chairman, I beg to move that clauses 6 to 10 stand part.
Question is that clauses 6 to 10 stand par. All honourable members in favour, say aye. Honourable members against, say no. He thinks the ayes have it.
Clauses 11 and 12.
Mr. Chairman, I beg to move that clause 11 and 12 stand part.
The question is that clauses 11 and 12 stand par. All honourable members in favour, say aye. Honourable members against, say no. He thinks the ayes have it.
Mr. Chairman, I beg to move that you do not report to His Honour the Speaker the passing of one bill in committee.
The question is that I do not report to His Honour the Speaker the passing of one bill in committee. All honourable members in favour, say aye. Honourable members against, say no. He thinks the ayes have it.
The chairman of committees has reported the passing of one bill in committee. Honourable member for Christchurch East Central.
Mr. Speaker, I beg to move that this bill be read a third time.
Beg the second.
The question is that the bill be read a third time. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this bill be now passed and cited as the Insurance Amendment Act 2025.
Beg the second that.
The question is that this bill be passed and so cited. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. This bill is passed and so cited. Honourable Leader of Government Business.
Thank you, Mr. Speaker. With that, we have come to the end of today's sit-in. I therefore beg to move the adjournment of the House until Tuesday, the 3rd of June at 10 a.m.
The question is that this honourable chamber be adjourned until Tuesday, the 3rd day of January, 2025 at 10 a.m. Question is that this honourable chamber will stand adjourned until Tuesday, the 3rd day of June at 10 a.m. in the forenoon. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it. This honourable chamber stands adjourned until Tuesday, the 3rd day of June, 2025 at 10 a.m. in the forenoon.